Wanted to keep all the chloroform evidence out of the case. So let's bring back in Donald Schweitzer to talk about this crucial ruling. He's a trial attorney and former prosecutor. Donald, great to have you back. Donald, let me ask you, what do you think is the impact of this ruling?
I don't think that it's going to have much of an impact because the defense has hired the very best that they can to poke at the scientific evidence in this case. They've got great experts, they've got great attorneys, and it's really going to fall down to whether or not the jury believes that the methods were used. I don't see it as that big of a setback, and I don't think it's a surprise for the defense. The defense knew that this evidence was coming in. It's well established that it should come in based upon appellate court decisions.
You know, Donald, a lot of people say, well, you know, the defense keeps losing motion after motion with these evidence rulings. What's going on? Is this a case of real setbacks for the defense, or is this a defense team that's kind of trying to throw whatever they can against the wall and see what sticks?
Yeah, Ryan, I think you know that in a criminal trial, the defense is always filing motion after motion. And 95% of the time, those motions are denied. They do that for a variety of reasons. One is they want to see what they could get in or what they could trick the judge with, or they want to set a record. I mean, if there is error, they've got to file the motions in order for an appellate court to rule. So they're just going to just paper the trial court with all these motions and hope that something sticks. But realistically, most of them aren't granted.
You know, Donald, there's another problem with this chloroform evidence that the defense tried to get across in the pretrial hearing, which was this idea that Dr. Arpad Voss detected trace amounts of decomposition. And the idea is that from that, there might be the extrapolation that the decomposition was Kaylee. That's an inference that the jury could end up making, even though he didn't find anything chloroform-wise related to Kaylee. It was just finding the evidence of decomposition. I have to ask you, is that dangerous to put that kind of notion in front of the jury in which they could possibly infer that it was Kaylee without having that hard evidence?
I don't think so. Good prosecutors, I should say, love circumstantial cases. That's what makes it challenging, and that's what separates the adults from the children in trial attorneys. If you could prove a case through circumstantial evidence, you're a great attorney, and that's what these prosecutors should be facing here. Is we got a tough case. This doesn't really point strongly in one direction or another, but it's a modicum of evidence, and they're going to throw everything in there and try to paint a collage, you know, have a picture as to what really happened. So it's good evidence for the prosecution, so long as the prosecutor's up to speed and is able to deliver.
Well, what do you mean is able to deliver? What do you think the prosecution needs to deliver in this circumstantial case? They've gotten some rulings on their side that gives them a little bit more substance, a little more hard evidence, but what do they need to do in your mind?
They've got to tell a story that makes sense. They've got to start off by letting the jury know that the statements made by Casey Anthony doesn't make any sense at all, and just paint a picture, you know, day by day as to what was transpiring when this child was missing, where the mother was, this phantom nanny. Just tell the whole story in a very convincing way. This is where lawyering is at its best, and we hope, you know, that we see on both sides of this case a great trial, because it's going to come down to the lawyers, I think.
So talk to me about the lawyers. How you've seen the pretrial hearings. What is your sense of how this plays out and whether or not they'll each be able to offer really effective arguments? This is a huge trial, and we've seen a lot from both sides.
We got very good attorneys on both sides, and I think as important is both of them have had an enormous amount of time to prepare for this. The prosecution in this case, as well as the defense, ought to have already written out their closing statements by this point. They should have videotaped themselves. They should have had focus groups. I mean, we're going to see people coming in, and the trial is already done in their minds because they've prepared so well. That's what I would expect to see, and that's what I'm seeing so far. I think that the interview with the defense attorney in this case shows that he's very relaxed. He's ready to go. He's not saying that whether he's going to win or lose, but he certainly looked ready to me.
All right. You know what? From talking to him, he definitely did seem relaxed and ready to go.
Yes.
Donald, so great to talk to you again. And folks, you know, I recently spent several hours talking